this evening, and I have to disclose something immediately, is that when I was invited to participate in this panel, I was kindly invited by the organizers, but I mentioned that what I will talk about tonight is a work in progress, so it's incomplete. There are, I'm sure, many lacunae. It's not well organized, or at least not organized as an academic paper. But I hope, nevertheless, that it would be of some interest, at least to some of you. I would start by thanking two persons with whom I have worked a lot on this topic for many years, because it's a work, it's a journey that we embarked on many years ago. Michael Schinazzi was mentioned by Charles Jarosson a few minutes ago, and Virginia Hamilton, who you may not know, but who was the editor of the Bulletin of the ICC Court for many years. And of course, a number of ICC interns who helped us digging into the archives and trying to understand all ICC awards who were typed on paper of very bad quality and sometimes difficult to read. Now, the idea, when we decided to look at the history of international arbitration and ICC arbitration more particularly, was to give an overview of the very beginning of ICC arbitration. Quite a lot was published on arbitration in general. Few things were published on ICC arbitration, but surprisingly, no one really went into the archives and looked at the first awards. So we decided to do that, or I decided at the time to do that, and with an idea, which was precisely to do what we are trying to do tonight, is to compare past practice with current one. And try to learn, if possible, or to find some lessons from past practice or the evolution of the arbitration practice. So we studied slightly more than 100 awards in the early days, starting from the very early days of ICC arbitration in 1922, so even before the court was established, and ending in 1967. Most of the awards were in French. A very limited number of awards were in English, and an even more limited number of awards was in German. So this is already something which is really interesting to note, that the vast majority of awards were in French. Proceedings were conducted most of the time in French. The court documents were in French. And of course, we will see this has an impact on the legal reasoning, the drafting of the decisions. So what are the key preliminary findings? The first one is probably regarding the time lag between the execution of the contract and the dispute. In the early days, it was only a few months. So that's something which is interesting, because it's no longer the case. Now it's more 2, 3, or 4 years. At the time, it was only a few months. The time between the execution of the contract and the dispute was shorter than today, especially during the first 10 years. After, the practice slightly changed, but at the beginning, it was almost immediate. When parties signed the contract, they had a dispute, they immediately went for ICC arbitration. Regarding the typology of disputes, well, it's not a surprise, but it reflects what arbitration, it reflects what international trade was at the time. The sector concerned were engineering, design of a machine, for example, sales of commodities, silk, cotton, tobacco, manufacturing items, from iron wires to luxury dress, distribution, edging. So, once again, not a surprise given what international trade was at the time. The subject matter of the dispute is slightly more diversified. well, it's not an exhaustive list, but I give you few examples. Deficiency of industrial equipments, quality of the goods, conformity with samples, interpretation of the trade terms delivered Franco-French-Belgian border at a suitable place to be determined by the buyer. There was quite a number of awards on trade terms, by the way. Reimbursement of the amount paid by letter of credit. And one very interesting award of 1927 described in a detailed manner the mechanism of a letter of credit and the impact of double payment due to a fraud. So this was a very, very interesting award. Almost, like a police report, an explanation of what happened and how the situation should be analyzed. Lead delivery, role of an intermediary, possibility to inform clients in the agent's territory directly, and calculation of the agent's commission in an agency contract, exclusive license agreement to reproduce and manufacture women's clothing, tax implication of a patent, cost shipment following currency exchange rate fluctuations. So nothing really revolutionary, and once again, good examples of practical difficulties that one could have expected in those days in international trade. Maybe more interesting is the arbitration agreement. So the agreement to resort to arbitration. There was, for legal reasons, lesser importance given to the arbitration clause. A substantial number of cases are based on a subsequent agreement, a compromis. Of course, because in the early days, the validity of the arbitration clause was not what it is today, and consent has to be reiterated. So in case of doubt, even after the Geneva Protocol, parties were used, and arbitrators were used to sign a compromis and clearly state in the award that they agreed, they consented to arbitration. About the participants in the arbitration proceedings, nationality of the parties, here again, it's a picture of what international trade was at the time. So you will not be surprised to learn that most parties were from European countries, but also from colonies. But vast majorities of parties came from Europe, and especially Western Europe. Few cases, it's interesting, were among parties having the same nationality. So French versus French, Belgian versus Belgian. So we can see that early on, in the first days of ICC arbitration, we had cases which were what we could more or less characterize as domestic cases in the fact. Regarding the nationality of arbitrators, once again, mostly Europeans. You would not be surprised, and I'm sorry to maybe to offend Claudia, but you will not be surprised to learn that most arbitrators were male, Europeans, Western Europeans at the time, and most arbitrators were appointed by the court. So that's something which is also interesting to note. In very, very few cases, parties appointed the sole arbitrator or the president of the arbitral tribunal or the umpire. So the role of the court, the ICC court, was really key in the constitution of the arbitral tribunal. National committees were also involved. So for those who are not familiar with ICC and ICC arbitration, you would learn that ICC is organized in a number of countries by national committees, which are local structure, local chapters that regroups ICC members in a country or territory. And these national committees have a role to play in the ICC structure, but in ICC arbitration, because, for example, they can propose arbitrators to the court. And that's what they did right at the beginning of ICC arbitration. They were immediately involved in the selection of arbitrators. Very few repeat appointments as well. So arbitrators were mostly appointed once. and a majority of sole arbitrators, or in the early days of Empire, so tiers arbitre, who was asked to determine the issues or the views between the two arbitrators appointed, for example, by the parties. The profile of arbitrators is also interesting because it is not what it is today. We know, when we study the history of the rules, that the drafter of the rules were very reluctant to involve lawyers, at least at the beginning, and it's formally recorded in ICC summaries of minutes of meetings that lawyers are complicating things. They are very often a nuisance to business people, and that they should intervene at the very last end of the process once all important things have been agreed upon by serious people, meaning business people. So that explains why, at the beginning of the process of drafting the first ICC rules, lawyers were not involved. They came in later, of course. But it's the same for arbitrators and arbitral tribunals. There was, at the beginning of ICC arbitration, there were very few lawyers involved. Most arbitrators were merchants, business people, CEOs, executives, senior executives of companies, professional associations and organizations, chambers of commerce. So a big change compared to what it is, a big difference compared to what it is today. And also, most of the time, parties were not assisted by external counsel. So they participated directly in the proceedings, very often at a senior level in the company, the CEO or a director, no lawyers. And in one case, this is funny because it's also related to the ICC structure, one of the parties decided to be assisted by the ICC National Commissioner. The National Commissioner is the representative of the National Committee in Paris. At the time, it was difficult to travel. So national committees, which were all around the globe, were asked to appoint a representative in Paris to vote on behalf of the National Committee in ICC meetings. And this person was involved in an ICC case and asked to assist one of the parties. Experts were used from time to time, but not very often either. So that's interesting, once again, because you can see that the format of the hearing was small. Regarding places of arbitration, nothing to say, mostly European places. Arbitrators, conduct of the arbitration proceedings, arbitrators were acting as amiable compositor in the early days, most of the time. And it's also interesting to note that they paid a great deal of attention to the attitude and the behavior of the parties. And you can find in awards nasty comments about the attitude of one party, saying this person did not even respond to my comments or did not say hello to the counterpart. And that was one of the reasons why that party was ordered to pay X thousand francs, French francs or mark to the other parties because that party did not behave in the arbitration. Something that we rarely see today. Also, and that echoed what was said by Claudia in her opening speech. In one case, when one party refused to pay the advance cost, or not the advance cost, but the full amount of the advance, it was decided by that party to show his good faith that the party was willing to pay, but opened an escrow account and deposited the money on an escrow account to show that it satisfied its payment obligation, but did not want to finance the proceedings. So we had a case, an early case, with this mechanism of an escrow account. I will conclude by the drafting of the awards, and I said by Charles, interesting, awards were in French, very short. Shorter much shorter than now, 9 pages in French, 6 pages in English on the average. Almost all awards were final awards, and very often in the awards, it is indicated that parties will not challenge the awards. So they commit not to challenge the awards and to comply with the decision of the arbitrator. So that's interesting to note, because we could very well see in the early days that there was a real trust in the system, in the ICC mechanism, in the arbitrators as well. Parties were confident that a short hearing or no hearing at all, having a case decided on document, was enough. It was not necessary to have long meetings, and arbitration proceedings, as I said, were very short. Usually the award was rendered within 2 months.